Hi, this is Erica, and I'm the founder of Perfect Legal Video. And I am very excited to have with us on the show today Attorney Nicole Reeves Lavallee. She owns a family law firm. They also work with real estate transactions. They are located in the Worcester area, and every week we have very interesting topics. Today, we're going to be doing a behind the scenes look at what attorneys are doing when they leave you and they say, I'll be right back. I got to go, do something, talk to someone, find something. Are they working or are they just having snacks somewhere? I'm just kidding. But welcome, Nicole. Thank you so much for joining us.
Thanks for having me, and you'll be interested to find out what we actually do.
Perfect. All right. So let's talk about, the obvious thing is that, I feel like there's a lot of scheduling and negotiating. Can you talk about some of the circumstances where you're doing something like that?
Yeah, the first thing we're going to do is we, as attorneys individually, are going to figure out which courtroom you're in. And make sure the file's there. Sometimes the file is, hey, you have to go report to probation, or hey, you have to get a print out at DOR, or hey, we're here, we're waiting for you. Why aren't you in the courtroom? So first and foremost, we've got to figure out where the file actually is and where we're supposed to be. Sometimes it depends on the courthouse is properly marked. Sometimes the court is going to go, yeah, go there, and then you go there and they go, we don't have that. Why are you talking to us? It's over in somewhere else. So first thing is always finding it. Sometimes it's simple, sometimes not so much. But again, that's the question. Once we find it, is that particular person looking for information from us? So if the file is in probation, then I know that they're going to need a financial statement. I know that they're going to need a probation intake form. I know that they're going to need an envelope. Those are things that are mandatory. And then if it's a pretrial, we're going to need a pretrial memo or something of that nature. So I need to hand all that stuff in, which means I'm going to then take that form, go back to my client, say, hey, you have to fill out this one form, and then I have to go stand in that line again. So if it's in probation, we're going to be standing in lots of lines. You want to walk with me, that's fine, but most people don't really want to just stand in line and sit there and watch me. They get to sit in their nice seats, and now if they give it up, they're not going to be there when they get back. So sometimes it's that simple. Sometimes it's, again, the court says, oh, I need to have this document and John Smith has it. So I've got to go find John Smith and find that particular document that they're looking for and bring it back to the clerk. So a lot of it is just running around. It's me getting my exercise, which is really good. Not so good for you because we can't start our case until everyone has the right documentation and is ready to go. So a lot of it is just running around trying to find the right people and making sure that they have the right information so that we can properly present your case to whoever it may be, the judge or probation.
That makes a lot of sense, especially when so many hands are involved in so many of these processes. And then there are unorganized people who say, hey, I didn't get that. That's why a lot of times you send stuff by mail, right? Because email is such an elusive situation. Sometimes there's junk email folders. There's, oh, I forgot to copy you on that. Or I thought I sent it. I thought I hit send. Oh, it's still sitting there. We're all busy. We know that happens. Is that a big part of it as well?
It absolutely is. It's one of those things that you're going, or if somebody waited till 11th hour. Well, I thought I could email it to the clerk. Okay, well, great. We're not doing COVID protocols anymore. So no, that's not proper. You need to e-file it or you need to bring it in. So you'll have people that want to take the easy way out. And then they go, oh, well, I thought you got it. Well, magic, you thought I got it? Because that's not the proper procedure. The proper procedure is you have to have these things in within 3 days. So sending it to me at 8 o'clock at night for a 9 o'clock hearing the next day, no, I'm not going to look at it. I'm not required to look at it. So even if I did get in and went to the proper folder, again, that just kind of has a problem. So now I'm going to say, go make copies of it and I'll get the copy because I'm entitled to that. I don't want to be looking at it on my phone. It's not proper for me to be looking at it on my phone. I certainly can't do it in front of a judge and have any kind of rapport with the judge that goes, yeah, I'm professional, but let me read this. Well, she said in this, you can't do that, guys. You've got to have the documentation ready. So I'm going to send, opposing counsel off and go, no, make me a copy. So we're having a lot of that too, back and forth. But again, you got to have the paperwork ready to go.
That's interesting. And I remember that happening when we went to court many years ago now. But yeah, I mean, I don't know. You just like walk off with the other attorney, and I assume things are getting done. Like, I mean, there's sometimes people, all of a sudden we weren't on the schedule, and then there was like chasing around to figure out what happened with that and why we weren't on the schedule, why one person was given that information and the other one probably just wasn't paying attention. Let's face it. But I mean, that kind of thing happens a lot.
The simple fact of the matter is, in your particular case, it was, well, we have only one motion, but there was two motions. Well, where's the second motion? Well, I don't know. Where's the second motion? Okay, well, we have to get it docketed. So now we had to give them our copy to go, hey, we've already got permission to do this. So you'll have those nuances because you're talking to the clerk who said, yep, do this. And then another clerk says, no, you can't do that. So we're just going to put it in a separate spot. Or I mailed it in, but I mailed it in 2 weeks ago. Oh, it's probably still in the file room. We're really backed up. It's 2 weeks. What are you guys doing? So you run into those problems all the time. And so now they go, okay, give me your copy. And then they take your copy and then they wander around to the mailroom and to everywhere else under the sun till they can find it. And they go, okay, yep, you're all set. Well, can I have my copy back now? So, as an attorney, you've got to make sure that you're aware of what's happening with the document that you gave away, because you're not going to get it back unless you ask for it. But that's what they're doing. A lot of times they're looking for that document. They don't want you to sign another copy. We can all sign another copy of the pleading, but they want the one that we've already filed with the court. Well, if you filed it with the court, we need to have that one. Okay, well, do your job better, and then we wouldn't be waiting till the 11th hour. So you do have that. And a lot of times, like I said, it's running around. It's working on your case so that we can get it in front of the judge, and the judge has all the information they need regarding your case.
I mean, and that makes sense. So there's another situation that it kind of reminds me of, someone got called to the principal's office or something. You can tell I was a person that was very paranoid. I didn't get in a lot of trouble, but I was always paranoid. But yeah, no. So what happens when the attorneys go in the chamber with the judge? Like, what are they talking about? What are the situations that would require that private meeting between the lawyers and the judge?
Well, sometimes it is private because the judge wants to yell at one of the attorneys, or wants to get information from one of the attorneys. But sometimes we request it. We say, Judge, we really don't want to be on the record. We want to be able to talk more candidly with you. And we're allowed to share a little bit more information that we don't want on the record, because the record is a record. Once you go into that courtroom, there's a recording of it. So sometimes we're allowed to say, I get it, but my client is really insistent in this. Well, counsel, it's really unreasonable. I get that, Your Honor, but I've told my client this 25 times and they don't listen to me. Maybe if it comes from Your Honor, light bulb goes off. The judge gets on the bench and goes, because he's telling me the same thing that I'm telling my client, but my client's not hearing it. When the person in the robe says it, now all of a sudden it makes sense. It's not that I'm trying to sway you and go, oh, no, that's wrong. I've already told my client and the judge exactly what our position is. But the judge is going, counsel, you're out of your mind. That's not happening. And I go, I understand. There's only so much I can do. And when I go, I understand, Your Honor, but my client is very adamant. Yeah, I'll talk to your client. And that's really how it happens, is that the judge is going to go, no, why are we having this conversation? Because again, the person in the robe makes more sense than your attorney sometimes, and they need to hear it. Sometimes it's because we don't want to share information. It's very touchy subject. Maybe it's a rape issue or an incest issue or something that you kind of go, don't really need to have this on the record. Let's just have an informal conversation before we have to say it. And if we have to say it, we will say it. But a lot of times when we have that kind of conversation with the judge will then allow us to close the courtroom. So at least there's only the four of us there and the judge. listening to this conversation, and everyone in the gallery isn't going to hear your dirty laundry. So there's times where it's appropriate, and a lot of times we need to ask the judge for permission. We can't just say, Judge, can you close the courtroom? They're not going to close the courtroom for you. So we need to ask, and that's the reason why we have an in-chamber hearing. Could be a 5-minute hearing, could be something that just goes, this is what we're talking about, Judge. We really need this closed because it's a sensitive topic. And, like I said, you're sitting there and you're going, I don't really want everyone to know what's going on in my case. Again, I can't stop it in most cases, but obviously when you have a highly sensitive topic, we want to make sure that you're protected.
I mean, and that makes sense. And I didn't realize that they could close the whole courtroom in certain situations, and that, certain things aren't going to come up until you're there because people don't want to have it in writing flying around, I'm sure. So, I mean, that is, very interesting. Talk about some of the negotiations that you have with the attorney. I mean, I know that you have plenty of clients that just don't like their ex, to the nth degree, and can't even really stand to be near them or in the same room anymore. I mean, and it's too bad when it gets to that point. But are there situations where you're just like, you know what, I get what you want. Like, what do you want? This is what you want. I'm going to go see what we can come up with. And then, like, what happens when you have to do that? What are some of the situations?
It's much more beneficial for the two attorneys to talk. Regardless of how amicable or non-amicable you are, the other party knows how to push your buttons. That's the bottom line. So if you let us do our job and you're saying, hey, I want X, Y, and Z. Got it, Erica. I know. I understand. I'm going to go in there and I'm going to fight for X, Y, and Z. And that's what I'm going to fight for. But we're doing it in such a way where, again, there's not hostility. Whether I like the other attorney or not, I really don't care. My job is to zealously represent you. So I'm going to get that point across. And they're going to say no. And I'm going to say, well, if you don't want X, Y, and Z, this is the reason why. This is my rationale. So I'm going to have that conversation. I'm going to negotiate till the cows come home. And we're going to go back and forth. And they're going to say, well, I can't give you X, Y, and Z, but I can give you X, Y. Okay, fine. And then I turn around and I go back to you and I say, okay, well, this is what they're offering. But in exchange for Z, we're going to get A instead. How's that work for you? And so it is that negotiation. But again, if you were there and the other party is there and there's that hostility, they're going to push your buttons, you're going to push the buttons, you're going to go, no, I'm not settling just because. Okay, great. That's not helpful to us. You've already told me what your position is. You don't now get to renege because your ex is being a jerk and saying something you don't like, because you have to look at the big picture. And as much as I'd like to take your money, it's really a waste of my time to sit there and negotiate it. So again, if we're having that situation, we have to have a four-way. But then when we're doing it in the courtroom, we're negotiating without you knowing exactly what you're saying. And don't think that, we're just buying time. No, we're not. We're actually zealously representing you. Whether or not the other party agrees or disagrees, that all depends on, again, how your ex responds. Your ex might be digging his heels in and going, absolutely not. Well, they're doing their job. And so then we go, okay, fine. Neither one of us can come to an agreement. We'll let the judge decide. Or we'll let the judge give us his opinion on something. And that's really what we're looking for.
And that makes a lot of sense. So this last question is about when it seems like your divorce is going on forever, and sometimes you just don't hear back from your attorney, or your attorney is doing everything they can to get answers from the other side. And there's like all kinds of reasons for it, like that maybe you're not getting the right documentation, so you're not moving forward. I mean, there's a lot of things. Then sometimes you just stop hearing from the other attorney altogether. It's like you're at a restaurant and they just forget to bring the check. I mean, it's something that happens far too often. Like, what are some of the reasons that it seems like your process has stalled and you're just not hearing back from one of the attorneys in the situation, or maybe even both?
I think, best thing to do is always reach out to your attorney and kind of find out what's going on. I'm a firm believer that I don't need to waste your money. I'm not going to call you up to say, hey, Erica, I don't know what's going on. I haven't heard from the other side. But do you need to chat? Let me run up your bill. That's not who I am. So I'm not going to do that. But I'm going to tell you, hey, look, we're waiting for discovery. It's going to be about 30 days. When I get it, I'll let you know. So if you want to talk to me in the 30 days, great. But you know what I'm doing. So I try to let my clients know what I'm waiting for. Sometimes it's, hey, I made an offer to the other side, like I did yesterday, and I was supposed to get an answer back today. And the answer was, well, I need more information. Well, really? Because you've had this exact same information for 2 years now. And their response is, well, I don't agree with your numbers. It's in black and white. And their answer is, I still don't agree with the numbers. Now, in that particular case, it's because the other party just doesn't want to settle. They want to run up bills. So sometimes it's just that simple, that they're trying to run up bills. Sometimes it's they really don't understand. Sometimes it's I need a real interpretation of this document because it's unclear to me. Obviously, it's a bank statement. We know what a bank statement looks like. But when you have things like pensions or other things, it's not just cut and dry. There's not a number on the page that you can go, yep, that's the number. No, it's a pension. They're not a real tangible number. So you need to have a third party look at it. So sometimes it's that simple, but a lot of times it's mostly boils down to, well, my client hasn't gotten back to me. I've reached out to them 25 times. I don't have an answer for you. I'm sorry, counsel. Or it's, hey, my client believes that my numbers are right, so we're never going to come up with an agreement. So it's a lot of that you'll have the back and forth and you really don't know the answers. It's not because we're not working on it. We might not be actively working on it, but we're probably sending a phone call or an attorney or a phone call to the attorney every 2 to 3 weeks going, hey, what's going on? If we don't hear anything back, again, at some point, I'm either going to have to file a motion to compel or a motion for the court to do something, or I'm just sitting and waiting. Sometimes it's, well, we have a trial date and I can't make them negotiate with me. So there's a lot of reasons, but really, realistically, check in with your attorney if you're feeling like you're not getting any answers. Sometimes the answers are going to be, I don't have any answers for you, and you have to accept that. But you at least want to know the basis and the reason behind why you don't have an answer.
And that makes a lot of sense. I mean, it's hard when you have so many people that are part of the process and not everybody is on their game. Or like you said, people have ulterior motives and it's hard to figure out sometimes, but as long as you're following the process and what the judge expects, then you're doing well. I mean, I think, is that right?
Yeah, I think for the most part. I mean, there's times where the judge just kind of yells at you and you're like, well, I can't make them come to the table. But you can't really say that. You're like, I reached out to counsel, Your Honor. And, that's all you can really say. And you kind of take your lumps and go, okay, judge, beat me up some more. But it's not one-sided. But that's, the judge is going to see that. The judge is going to say, you two aren't settling this case. This case should not be tried. I get that, Your Honor. I understand completely. Whether I have the difficult client or not, simple fact of the matter is I can't make either party sign. And I'm not going to. So my job is to advise my client and let the client make that decision. And sometimes that decision results in, well, counsel, if you go to trial, and I hear the evidence today, I'm probably going to award attorney's fees. That's usually the thing that makes my client go, oh, if they're being the unreasonable one.
Well, this is all very interesting to have the inside look at what's going on and the reasons for why your attorney is ducking out to go discuss things. And, really, the nicest thing about having an attorney work for you is that they know what needs to be there, how everything works. I mean, if you have a good one, obviously, and if you don't, and you think you could do better yourself, you probably still can. But if you think you can, then maybe you need a different attorney for sure. I mean, you must see a lot of that too, where it's just like people just aren't going by the right process.
Absolutely. I mean, you get a lot of pro se litigants and they just, they'll say, well, we don't have this document. Okay. And they'll sit back in the courtroom. Sir, I've told you I don't have this document. Okay. Well, you need to go get it. Well, where do I get it from? I'm not an attorney. You'll have to figure that out. And that's what you're going to get from the clerk. So when you're in that situation, you're like, okay, well, now what do I do? And guess what? If I'm on the other side and it's your document, I'm not following you around. I'm not going to chase it. You've got to do it. The only way I do that is if it's costing my client, because you're going to not know what you're doing, and I'm going to be sitting around for 3 hours. But, you know, a lot of times it's, well, you're supposed to fill out the financial statement. Well, why didn't you fill it out? Because I didn't know I needed to. Well, you need to fill it out. I can't stop you. I'm going to sit here and wait. And then I'm going to report to the court that it took you 2 hours to fill out your financial statement, and you did it right then and there in the courtroom, and my client should be entitled to her attorney's fees. So there's ramifications for doing it yourself and not knowing how to run around and who to talk to and all of those good things that we're doing.
And you heard it here first, folks. Well, thank you so much for coming on today and giving us some insights to what goes on with the attorneys. So I want to thank everybody for watching, and thank you so much, Nicole, for giving us these insights to what goes on with the attorneys and what they're doing when they do their job, all the things that we don't understand. So we really appreciate that. Looking forward to the next topic next week, and I hope everybody enjoys their weekend. Thanks again for watching. Have a great day.